Court ended earlier than expected today in the trial that everyone is talking about, the murder trial of Lindsay Clancy, the Massachusetts mom accused of killing her 3 children back in January of 2023. The circumstance was apparently unforeseen. Judge didn't explain why, told jurors not to speculate, not to hold it against either side. But before that happened, something substantive happened. Defense psychologist Dr. Paul Zeisel took the stand again today. And he testified that Clancy didn't appreciate the, quote, wrongfulness of her alleged crimes due to severe postpartum psychosis and mental illness. That is a key legal definition of insanity. Here's that.
My opinion is that she did have indeed a mental disease or a defect. That's a legal construct, not a DSM-5 one, but she had bipolar disorder with postpartum psychoses. In addition, she was unable to conform her behaviors to the rule of law, and she had no appreciation for the wrongfulness of her act.
The doctor went on to say that Clancy has been struggling for weeks, reporting suicidal thoughts, paranoia, voices in her head. Prosecutors, though, they pushed back. They challenged that testimony, saying Clancy's medical records didn't specifically mention voices telling her to kill her children, that she had the presence of mind to send her husband out of the house before killing her children. They also called Dr. Zeisel's close relationship with the defense attorney, Kevin Reddington, into question. Now, this trial is expected to continue tomorrow, but came out that defense now is expected to call just one more witness before resting its case. Then we may see the prosecution call rebuttal witnesses. If convicted, Clancy faces life in prison without parole. If she's found not criminally responsible because of mental illness, she would be essentially committed to a state psychiatric hospital. Joining me now for a closer look is Donte Mills, a national trial attorney with Mills Legal LLC. Good to see you, my friend. Thanks for taking the time.
Of course.
What's an unforeseen circumstance that would, mess the whole day up?
I don't know if it's even worth spending time trying to guess that, because it could really be anything.
Anything substantive?
Somebody had to go to the restroom, somebody had a doctor's appointment. It truly could be anything. And there's really no way to know that, because from scheduling to everything else, things happen. We're normal people. The judge is a normal person. The lawyers are normal people. The jury, someone on the jury could have sent a note in saying that, they had a doctor's appointment or something happened with their child. You just don't know. I've been on a lot of trials, and I've had everything in a book come up to where we had to end the day short.
I'm going to correct you. Lawyers, us lawyers, we're not normal people. We're not normal people. Okay. I thought Dr. Zeisel's testimony encapsulates this whole trial. Right? Really great witness for the defense, talking about that she hears voices, that she couldn't conform her behavior to the law. It's essentially what the defense is arguing. But at the same time, there was no other documentation apparently about this. Close relationship with the defense attorney. This idea that if that's even true, it's not just, if she has mental illness, that's only one part of the analysis. Did she make a conscious decision? How important do you think his testimony is? How much did it change the game?
I don't think his testimony changed the game. I think his testimony gave the jury an opportunity to see that narrative and say that she was, in fact, legally insane. We have to remember that mental illness and legal insanity, there's 2 different things. You're not going to hear many more, it's just one more witness from the defense. It's because the evidence is all the same. All of the evidence has already been put in about the history she had before the murders took place. It's just how you frame it. The prosecution is saying that history was there, but she still knew what she was doing in that moment. The defense is saying that history is there, and that shows she didn't know what she was doing in that moment. All of the facts, they're using the same bucket of facts here. It's just how you want to look at it.
So you're not surprised the defense seems like they're about to wrap things up. They feel like probably have done enough through cross-examination of the prosecution's witnesses and their own?
Yes, they would have brought in the same evidence and facts that the prosecution brought in. They're just telling the jury to look at it a different way. Because if you look at the facts that came in, the appointment she went to, the help she tried to get, the medication she was on, that's proof to you that she was struggling to the point that she was legally insane. And the prosecution's using the same evidence.
Just to play the other card, I would say the strongest evidence for the prosecution is the allegation that she led her husband,
yes, the planning,
go out, get takeout medication while she killed the kids, exercise bans, very deliberate, 3 separate deaths. It's not as if you put the kids in a car and, have the engine running. It's 3 separate acts. So I think that you can argue that's, voluntary, it's deliberate.
Thank you for watching. Subscribe below and download our NewsNation app right now on your phone, and you will get fact-based, unbiased news for all Americans.